United put together a 90-minute movie on Hillary Clinton. The Supreme Court, the majority of the Supreme Court, Justice Kennedy, who wrote the opinion in Citizens United, described it as pejorative, highly critical of Hillary Clinton, and said you couldn't watch this film and see it as anything more than a movie that was actually a negative campaign ad regarding Hillary Clinton. It was clearly electioneering activity. It was shown in theaters for a little while. It didn't get a lot of acceptance there, and they decided they wanted to broadcast it on demand on cable companies. And so they found a cable company and paid them $1.2 million to broadcast it on demand, and produced 2 television commercials that they wanted to air on broadcast television promoting the movie. They wanted to do this during the blackout period that was prohibited under McCain-Feingold, which was within 60 days of the election. Now, the way that things tend to work from time to time, it's not as if the FEC came to Citizens United and said, no, you can't do this. Citizens United had this plan, and they filed suit to ask the court to declare that this was legal, right? That what they were doing was legal. And they had a number of fairly esoteric reasons for believing that it was legal. But the court focused on just a couple, all right? And I want to talk about those. So the case bounced around for quite some time before that. The Supreme Court was argued twice by the Supreme Court. And in a 5-4 decision in 2010, the United States Supreme Court decided that the federal government, through the Federal Elections Commission, did not have the right to prohibit Citizens United from airing this movie about Hillary Clinton within this blackout period. And the reason that they said it, I think, is why we're here today, and what most people found so startling, was that the court said for the first time that regulations which prohibit corporations and labor unions from spending money from their general treasuries is an impermissible infringement on their rights under the First Amendment, and the government may not do it. The government said there were 3 reasons it had the right to do it, right? Reasons that have been recognized previously by the court as appropriate reasons for regulating speech. The first one is anti-distortion. Distortion is a recognized thing that happens when one party has way more speech than the other. The government also argued that it wasn't fair to shareholders of corporations because they own shares in the corporation. Their money was going to be used out of the general treasury to finance these, and these ads or messages that come from the corporation they might not agree with. And so their money was going to be used to promote ideas that they didn't agree with. And third, the government said that it leads to corruption or the appearance of corruption. And it erodes people's confidence in the system. And when people's confidence in the system is eroded, they stop participating. They stop thinking that the government works for them. They stop thinking that they can have an impact on policy. And when that happens, you get bad policy. And you don't get the kind of government that we want. So you have essentially the distortion argument, the corruption argument, or appearance of corruption, and then the shareholder argument. Now, I struggled a little bit with how to present the decision in this case, because the way that opinions are written from the courts is that you have a majority opinion, which typically represents the view of the majority of the justices who agree to a particular ruling or law. And then you have dissenting opinions from judges who don't agree that that's a proper application of the law. And then oftentimes, as is the case here, other justices write about different points that they want clarification on. And as I indicated, Citizens United was a 5-4 decision, and the majority opinion was written by Justice Kennedy, and in it he lays out his reasons for why he thinks that this is unconstitutional. Justice Stevens wrote a very long dissent explaining why he thinks Justice Kennedy is wrong. And there are lots of issues in that case that we could discuss. It's a very complicated area of the law. But as it relates to these three, I wanted to talk to you about what Justice Kennedy thinks and his rationale, and what Justice Stevens thinks and his rationale. And I'm sure that you will note some bias when I discuss the differing viewpoints of the justices, but it's really not my intent, because there is certainly support for both of the opinions, some less than others, as you'll hear. What Justice Kennedy said was, in terms of the government arguing that there is distortion when you allow corporations to spend unlimited funds and they tend to drown out the voice of other speakers, the court said that the government doesn't and shouldn't be in the business of equalizing speech. It's not the job of the government to make sure that everybody's voice gets heard. It's the job of the government to make sure that everyone gets a right to speak and that they don't interfere with their right to speak. But we can't go around making sure that they'll be heard, right? We can't provide access to everyone. So that's really not our job. And the government shouldn't be in the business of dictating where you get your information from. It shouldn't be saying, we think that the ACLU is a good place to get information from, but General Motors is a bad place to get information from. That the ACLU, or that the League of Women Voters is a reliable source and Exxon's a terrible source. That is not what the government should do, and that's essentially what we're doing when we say just corporations can't speak during this blackout period, and that's wrong. He said there's no such thing as too much speech. We want to promote speech. The more ideas that there are out there for people to consider, the better off we are. And so regulations that tend to limit speech are just bad, and this is one of those. And he said, and you can't make this stuff up, you shouldn't reject the speech of a corporation simply because it isn't a natural person. That information that comes from, from other than natural persons could certainly be reliable and interesting and something that we should rely on. As to the government's argument that this allowing corporations to spend unlimited funds from the general treasury promoted corruption, the court said corruption means just one thing, and that is an exchange of money for a vote.
Oh.
All right? That's what, and we see no evidence that that's happening, or that unlimited spending in this way by corporations will cause that to happen. And therefore, we don't think that this regulation really combats corruption at all. And that favoritism and influence are not avoidable in the political process, according to Justice Kennedy. And that the appearance of favoritism and access and influence will not turn average Americans away from participation in government. Now, there's not much support in the opinion for that, but that's what they say. And that ingratiation and access just are not corruption. As to the shareholders, the rights of shareholders of these corporations, he said there's lots of other laws that protect shareholders of corporations. They can file suits if they don't think that they are being appropriately represented by the board of a corporation. They can sell their stock if they don't like what the corporation is doing. And they have a right to go to shareholders meetings and vote on the conduct of the corporation. Justice Kennedy said, essentially, what this did was create an outright ban on corporate speech. and that outright bans are almost never appropriate, and this one most certainly wasn't. Justice Stevens, in his dissent, also dealt with these issues. And dealing first with distortion, he talked a great deal about corporations and their ability to control the media, their ability to saturate the media, and points out that while you often hear this thing about that there's no such thing as too much speech, that isn't necessarily true. There can be a thing called too much speech. There can be too much speech. And it can occur when one or another party has such control over the methods of speech that it tends to drown out other good ideas. And that the government has a role to play in making sure that doesn't happen. And that in this case, the role that the government chose, which was to ban corporate expenditure during this period, was an appropriate one. Justice Stevens said there's nothing wrong with limiting the speech based upon the identity of the speaker, if by doing so you're promoting the goals that we talked about earlier, more participation in the system and avoiding the appearance of corruption. In fact, we have a long history of regulating speech based on the identity of the speaker, and we talked about some of those things earlier. Students are treated differently, soldiers are treated differently. There are lots of examples of why speech gets treated differently. In addition to that, he talked about the idea that this was not a ban on Citizens United's right to speak. In fact, it wasn't even close to a ban on the right to speak. Citizens United, under existing law, could have formed a political action committee, and instead of spending the money out of its general treasury, could have formed a political action committee. In fact, it had a political action committee that had several $1 million in it, according to its books. And that political action committee could have funded this film if it chose to, and it wouldn't have violated the law. And the reason that PACs and political action committees are viewed differently by the courts is because if you have a corporation, one of the issues that we talk about is this unfairness to shareholders. If the corporation speaks in a way that doesn't represent the views of the shareholders, the idea in campaign finance is that you form a PAC then, right? So you ask individual employees if they agree with the position of the company on a particular issue, and if they do, they can contribute to the political action committee, right? That fund. And that's this check to make sure the corporations are actually representing the people whose money they're spending as opposed to just the stockholders. Justice Stevens also indicated that it should come as no surprise to anyone that the court found no evidence of what they call quid pro quo corruption. In other words, exchange of money for a vote. The idea that anyone would take the stand and testify they took money in order to vote in a particular way on a particular bill is outrageous. It doesn't happen, and that's why there's no evidence of it. But that we all know that certain people get access, and that access means something, and all we have to look at is how much they pay for it to know how valuable it is to them. And that common sense tells us that access and familiarity is a very valuable thing, and that it is traded as a commodity in Washington. Shareholders. Justice Stevens points out that the idea that shareholders can go and vote at the shareholders meeting and change corporate policy or sell their stock if they don't like what a company is doing is just silly. General Motors has 1.5 billion shares of outstanding stock. Exxon's 4.5. Sorry about that. Exxon's 4.5. Disney 1.6 billion shares. To say that any particular shareholder has any particular influence on the policy of those companies is silly. Plus, the expenditure often takes place long before the stockholder knows about it, right? So you don't know who's aired the commercial, right? And it's already happened. So it's not as if you could curb the conduct of the corporation by selling your stock. What was left in place to the great concern of Justice Thomas was the disclosure regulations. Citizens United not only said that it had a right to spend funds from its general treasury to run these ads, but also that it shouldn't have to disclose under the act where it got the money from to run the ads. And the majority of the court, including Justice Kennedy, indicated that there's nothing wrong with that. That it's perfectly appropriate to require disclosure of corporate spending and of all spending in campaigns. Now, candidly, it doesn't make a lot of sense, right? For example, the response when Justice Stevens said, well, they could have done this with a PAC, right? Citizens United could have run this movie with their PAC. The response from Kennedy and the majority was, that's too cumbersome. There's a lot of record keeping to be done, right? It's not an easy thing to do to set up a PAC and to organize the thing, and we just think that's an imposition on free speech. But disclosure requirements, which can be very cumbersome, they're all right with. Justice Stevens then urges, he didn't carry the day on his argument of whether or not he could regulate, but he urges that we enact disclosure requirements that are as strenuous as we can to provide people with as much information as we can regarding who's spending the money and why they want us to take the particular position they're urging us to take. So that's Citizens United. That's sort of the First Amendment, and as it relates particularly to these issues. And I think, as I said at the outset, it's important that when you look at these issues, it's important when we look at these issues that we do so carefully, because although we may not like the speakers and we may not like the message, we do like the First Amendment. We do respect the freedom of expression, and it can be very, very uncomfortable sometimes. And we have to ask ourselves, is this one of those times? And I would also suggest that as you think about what's an appropriate way to regulate campaigns and what sort of system we have, you concern yourself far more with the goals of campaigns and the goals of speech, and far less with the current Supreme Court holdings on what's permissible and what isn't. Because those change, and they'll continue to change. Citizens United is a 5-4 decision. If the makeup of the court changes, that decision could change. And that's not to say that that would solve all our problems. Because long before Citizens United, we had problems with money in politics. And it seems to me that we, for a very, very long time, lived in a place where even if the government had completely unfettered ability to regulate campaign finance, we haven't shown that we've had a great deal of interest in doing that. But we seem to now. And since we do, my suggestion would be that understanding the traditions of the First Amendment, understanding how those traditions apply to campaigns and political speech, you look at approaching the problem in a way that respects the fundamental right of everybody to have their say, but that nobody has more say than anybody else. And that the goals are that we want a system and a process where we exchange ideas, we listen to each other, and by doing that, we're able to make better decisions together about how we want to move forward as a society. And if we do that, if we design changes to the system with that goal in mind, one, it's more likely to be upheld by the courts, and two, it just makes for a better system, respects everyone's opinions, and hopefully gets us to where we want to be, which is a government that responds to our wishes and that makes policy decisions that are the good of all of us and not just a few. We have some time for questions, and I'm glad to take questions if anyone has them. I would like to just give a short plug if I could. We, as Marion mentioned, I'm on the board of Common Cause Michigan, and we are holding an event at our office on January the 14th at 6 o'clock. We're downtown in Traverse City on Front Street. And some of you, I'm sure, have seen Facebook postings about this or received an email from us already, but if you have not, what we are hoping to do is a lot like what you're doing. We're going to organize, we're going to roll up our sleeves and start thinking about real solutions to these problems. I've given so many of these presentations over the years where folks come up to me afterwards and say, boy, this seems like a big problem, what can I do? And I never really have a very good answer, and now I do. What we're going to do is we're going to sit down together, we're going to put our heads together, and we're going to come up with some solutions, and then to the extent that it takes resources to get them done, we're going to go find them. And we're going to start to move forward. And we're going to begin next Thursday night at our office with that process, and I invite you and encourage you all to come. And now if you have questions, I'd be glad to answer them. Yes, sir?
Hey, hold on, get a microphone for you.
Mhm.
Thank you.
Oh, you're welcome.
Excellent presentation. These are the rules from the state of Michigan.
Gary, if I, okay, for other questions, we'd like to keep them concise and short so we can.
These are the
get
rules
around.
from Michigan for cantoring contributions. A lot of rules. These were the cantoring contributions from one of the parties that ran in our county. This is the other party. Okay. Some of these aren't filled out correctly. My question to you is, couldn't this be said also about unions, what you're saying about corporations?
Well, the answer to the question is yes. It could be said about unions, and all regulation, well, the Tillman Act in 1907 didn't apply to labor unions, but unions were added in the Taft-Hartley Act in 1947. And every campaign finance regulation adopted since has included both unions and corporations. The same rules apply to both. The rules that were intended to apply to Citizens United, without question, applied to unions as well. And you're right, the paperwork is immense. This, by the way, is the court's opinion in Citizens United. So, I mean, you get a sense of how complicated these issues can be. Yeah.
Okay, I would like to
Oh,
use the
I'm sorry.
microphone, if you will. Honor me, please. Thanks.
You mentioned a couple of times that students and soldiers are treated differently, or they don't necessarily have the same rights as other citizens. I don't understand that. Why is that?
Well, there are two things. One is soldiers can be prohibited from political activity while in uniform, right? Governmental employees are prohibited from contributing to campaigns under federal law. Students, the Supreme Court has said, are not entitled to unfettered free speech. There are a number of cases involving student newspapers, for example, that dealt with topics that school administrators thought were inappropriate. whether the case has not yet reached the Supreme Court, but probably will, whether schools can require children to wear uniforms, right, as opposed to what they wear or how they wear their hair being an expression. Courts have said that schools have the ability to control speech so long as there is a legitimate educational reason for doing that. So they are treated differently.
Anne, and then gentleman, and then the woman, then the gentleman behind you.
Why is this not a civil rights issue when those with lots of money have more speech than other people who perhaps cannot even contribute to a campaign?
You know, that's a good question, and when you say civil rights, in the broadest sense, what you're talking about is rights guaranteed under the First Amendment or any of the other amendments, which prohibits the federal government from taking actions that are prohibited there, and then the 14th Amendment, which applies those same rules to the states, and then the 14th Amendment actually adds then the Equal Protection Clause, which says we are all entitled, every person is entitled to equal protection under the law. And that's a good question. The answer from the courts has been, we are protecting your civil rights. We are striking down every attempt by the government to silence you, and we are striking down every attempt by the government to silence anyone else. And so the fact that someone may be louder than you, that we can't help. But to the extent that the government attempts to silence you, we will step in. That has been the response from the courts. It's essentially, right, they have the right to print the New York Times, but the government doesn't have an obligation to buy it and deliver it to you. So that, you know, we all have this obligation on our own to become part of the public debate and to get our voices heard.
Actually, we're gonna go here, and then the gentleman.
Okay, sure.
And then
Just as a point of information, I'm a retired publications teacher from a high school.
Yes.
And when I first talked about First Amendment rights with my students, we had very different rules, and that wasn't that many years ago. But ultimately, as the court became more conservative, it took those rights away from kids. And it basically allows the administrators to have prior review to all publication and to stop almost anything that is said by a student, even the black armbands that you referred to, which terrifies me and makes me very angry. But I have another point. I want to know if you can draw a connection between this kind of a ruling that does allow for unlimited spending from those that have unlimited pockets to the disparity that we're having between the rich and the poor in our country.
I can. I can't do it on constitutional grounds, but it seems clear, right? I think most folks agree that campaigns are funded by a very, very small segment of the population. Very, very few people contribute to political campaigns, and of those who do, the amount that contribute, say, more than $500 is
Small.
less than 1/10 of 1% of the population. And it's also very clear, most people believe, and studies tend to show, that policy gets bent in favor of the funders, right? Those who fund elections tend to get policies that favor them. And since people who fund elections tend to be people of means, policies get bent toward people of means. An example, 2 years ago, Michigan doubled its contribution limits for candidates, right? The legislature in a series of bills that also gutted some disclosure requirements, doubled the amount of the maximum amount you could give to a campaign. Now, in the 2 election cycles prior to that, less than 0.5% of the people in Michigan gave the maximum amount, the lowered maximum amount. So the 99.5% that didn't contribute at the maximum amount. So the only people that benefited from doubling it were that 0.5% who gave the max and wanted to give more, right? And you see that unfortunately over and over again.
Dan, did the majority in Citizens United, did they dissect the First Amendment to discuss the concept that the amendment itself appears to focus on persons